Okay, we're going to get started. It is about 12:02. Welcome and thank you for joining us for Beyond the Restraining Order, Civil Options for Victims of Domestic Violence, presented by the National Crime Victim Bar Association and Jessica Dayton of ADZ Law. I'm Renee Williams. I'm the Executive Director of the National Center for Victims of Crime. A couple of housekeeping notes on today's presentation. I'm seeing that we have 385 participants and that keeps ticking up. So as you can imagine, having that many people on a line can be a little bit hard to handle. So we have a few ways we're going to do it. First of all, we're going to leave the chat option open for everyone to have conversations with each other. In order to do that, make sure that you are typing to all panelists and attendees. Otherwise, the conversation just comes to us. So in your chat option, please make sure you have all panelists and attendees. However, we will not be monitoring the chat for you all. So in order to ask a question of us, we're going to ask that you use the Q&A function, which if you hover towards the bottom of your Zoom screen, there are two little thought bubbles and they say Q&A. Go ahead and use those. I'll be monitoring those questions. I'll make sure to ask Jessica any of the questions that are timely as they arise, but we may hold some till the end. To that end, if we run out of time, we will stay on the line for an additional 15 minutes. These webinars for us have generated some pretty good conversation and we've tended to run over. So if you have the extra 15 minutes, we will try to answer your questions and you're welcome to stay on and ask any through that Q&A feature. Any questions we do not get, we will provide to Jessica to answer. She will send an email to us and we will then send her answers out. Finally, and I've already seen this question pop up a few times, this session is being recorded and it will be available on the NCVVA page, which is victimbar.org, and it will also be available on our YouTube channel, which you can find by searching the National Crime Victim Bar Association on YouTube. With that, I'm going to turn it over to Jessica Dayton. Jessica is the founding partner of ADZ Law, LLP, which is in California, and she is a certified family law specialist who dedicates her practice to representing victims of domestic violence, along with their civil legal needs, which would be restraining orders, custody and tort cases, as well as advising and advocating for victims' rights in criminal cases. She received her law degree from Golden Gate University in 2003 and her undergraduate degree from the University of Vermont. Jessica recently published Bridging the Gap Between Civil and Criminal Legal Systems for Domestic Violence Survivors, which details the importance of understanding and pursuing justice for victims in both civil and criminal court systems. She also serves on the advisory board of Family Violence Appellate Project and the boards of Women-SV and the San Mateo County Trial Lawyers Association, in addition to previously serving on the California Partnership to End Domestic Violence and the San Mateo County Legal Process Committee for Domestic Violence. So as you can see, we asked an expert to speak to you because this is one of the hottest issues that we usually face in questions. So with that, I will open it up to Jessica. And Jessica, thanks for joining us today.
Thank you. Good morning. I am so pleased to see how many people are joining us today and that all of you who have shown interest in this topic, and I certainly hope to do it justice. So thank you for taking the time to explore this topic with me. This morning or this afternoon, depending on where you are, we are going to compare the victim's role in a civil case versus a criminal case, explore the pros and cons for victims pursuing civil remedies, identifying the different tort remedies that are available for victims of domestic violence, talk about third-party defendants, the risks and affirmative defenses to pursuing civil remedies, and the intersection of the family law case and the civil case, including strategies to incorporate demand and settlement. And above all, opportunities for collaboration. This could be with district attorneys, victim advocates, law enforcement, etc. I have long believed that domestic violence law is its own specialty. It does not fall within one category. It is not civil, it is not criminal, it is not family law, it is not victims' rights, it is not bankruptcy, it is not probate, it is all of those things. And it's a subset of knowledge that transcends all of these areas of law. And for those of us who work in this area, recognize that it's an area of knowledge that is particular to the experiences of the domestic violence victim and an understanding of the power and control dynamics that run through all of the different areas of law. And because domestic violence victims have needs and rights that transcend all of these different areas of practice, if you're only knowledgeable in one area, it is quite likely that you are doing your client a disservice. So who are the different attorneys that come in contact with domestic violence attorneys? That come in contact with domestic violence victims. And I would say every single attorney, whether you know it or not, is in contact with domestic violence victims. But the most well-known categories are the district attorney. Now, the district attorney does not represent the victim. The district attorney represents the state. So their interest is in justice for the state and holding batterers accountable to the state. The victim is just a witness in the case. So while they have rights and while they have opportunity to be present and to be heard, it is not their case. In a criminal case, you might also have a victim represented by a defense attorney. This could be a defense attorney that's working in collaboration with the batterer's defense attorney, if that is what the victim wants, or it can be a victim's rights attorney who is advocating on behalf of the victim for either their rights throughout the case or for their stated interest in the outcome. We also have family law attorneys. The family law attorney is likely to have little knowledge of tort remedies. They will likely have litigation experience because family law is civil law, but the knowledge of the tort remedies and the other financial options for victims are likely outside of their wheelhouse. The family law attorney is likely focused on custody, division of property, and dissolution of the marriage. Perhaps in your jurisdiction, family law attorneys also deal with civil restraining orders, and so they're dealing with those protective orders, but they are likely not dealing with the civil tort remedy. Another strategy that I think is all too common in family law is to downplay the domestic violence. And it's downplayed, number one, because of misunderstanding. Number two, wanting to keep the case cleaner in front of the judge or keep it not blow things out of proportion in the hopes of settlement. And so I see time and time again, family law attorneys trying to minimize or downplay the actual violence or domestic violence in the relationship in order to reach a settlement. And while there might be strategic reasons to do that, it's not always a service to their client. And then the last category of attorney that comes in contact with victims is the personal injury attorney. This is generally where domestic violence torts fall within this category. However, your average personal injury attorney is also not accustomed to dealing with domestic violence victims. The dynamics of dealing with a client who has been injured by their intimate partner is worlds different than a client who has been injured in an auto accident by a stranger or medical malpractice. Certainly all of these victims have experienced emotional injury and they all are seeking restitution for their damages, but the dynamics of having your perpetrator be your loved one, be your family member, is incredibly different. And so therefore, quite often, personal injury attorneys are also not wanting to deal with the domestic violence torts that are available. So the result is that these remedies for domestic violence victims that we have within our civil system often go unnoticed, unpursued, and then the victim falls between the cracks of these different siloed areas of practice. And so what I want to talk about today is how they connect and how we as attorneys can address those needs from a global perspective. So we know there are two systems of justice. I'm not going to spend too much time on this, but it is important to recognize the victim's role as it pertains to these two systems. Like I said, in the criminal case, the offense is against the state. The victim is just a witness. They may or may not testify depending on your jurisdiction and what type of policies your district attorney are implementing. Whereas in the civil case, the case is brought by the victim. The victim runs the case. They make the decisions. Settlement is entirely in their hands. They are a part of every step along the way. And the purpose in the end is to make the victim whole, to seek financial recovery for the victim, as opposed to the criminal, which is punishment or rehabilitation of the offender. Now, there's not always a criminal case. There's usually not a criminal case where domestic violence is concerned. And so a victim may not even have the option of participating in a criminal prosecution against their abuser, and a civil pursuit is their only option. However, if there is a criminal case, that offender does not need to be found guilty in order to pursue a civil case. The most common example of this that everyone is familiar with is O.J. Simpson. Not guilty in criminal, yet civilly liable. So if your perpetrator is found not guilty, it does not mean that you do not have a civil case, and this is because of the different burdens of proof between the criminal and the civil system. On the flip side, if you do have a prosecution that is successful, that results in either a guilty plea or a conviction, that sets you up beautifully for your civil case, because that person has already either pled or been found guilty beyond a reasonable doubt, which is obviously a much higher standard than in our civil cases. For some victims, it does make sense for them to pursue all of their remedies through the criminal case. They may not want an additional civil case. They don't want to file something else. If there's been a criminal case, they've already testified, and they've had the opportunity to seek restitution. And in doing so, they will have provided documentation of their medical bills, property damages, lost wages, and had a restitution hearing through the criminal case. And so for some victims, this might be enough. Keep in mind that restitution is only out-of-pocket expenses. It does not cover all of those emotional or non-economic damages that are most definitely also present. The other consideration is that having a criminal restitution court order does not guarantee payment. Now, a victim can collect this in the same manner as a civil judgment, but this requires a lot, in my experience, a lot of advocacy and proactive work on the work of the victim. The district attorney generally ends their active participation in the case at conviction. Once that's done, in my experience, I have not found them too involved in collecting on that restitution order. It really, the burden is on the victim. And so some collaborations or ways that you can help victims is to connect them with advocacy groups to try to collect. That could mean reaching out to the probation officer, the parole officer, to the district attorney, filing something in the court, keeping in mind that it makes no sense for anyone for the victim to pay more money to collect on the judgment than what the judgment is worth. So whilst criminal restitution is an option, it is not necessarily always a viable one for all victims. So this is where we consider filing a separate civil lawsuit. And some of the advantages to doing so are indemnification. Chances are this victim of domestic violence has incurred many costs in the form of medical bills, therapy bills, attorney's fees in pursuing restraining orders, and a civil lawsuit can provide those financial resources that will help the victims rebuild their lives. Accountability. So while the criminal system holds the offender accountable to the state, a civil lawsuit is accountability to that individual. And so the victim can really get a sense of you harmed me and I have been successful in proving that, or you have admitted it, or you are paying up because you did it. And that accountability is a huge advantage for victims. As well are answers. A victim can get answers, explanations, and apologies through civil litigation, which are often just as meaningful as the financial recovery. I've had a number of cases where a part of the settlement includes a letter to the victim. In one case, it was an explanation of why he behaved a certain way and he thought it was okay to behave that way and the steps that he was taking to change his life so he didn't treat future partners in that same way. And to that client, that was very meaningful to her. And so these answers can come either in the form of your settlement or through discovery, through depositions. Even if you don't get those answers voluntarily in the form of a settlement, you can certainly get some answers, explanations through discovery. Civil litigation has the sense of control because, as I stated earlier, it is the client who is running the whole case, making the decisions through the case, what to pursue and how to pursue it, whereas kind of following along with what is happening in the criminal case. Personal justice. Regardless of what happens in the criminal case, the victim can still pursue this personal justice for him or herself for the harm that was caused to them. There are also incentives for crime prevention. So we're going to talk a bit about third-party defendants later on, but civil lawsuits certainly encourage other entities to engage in practices or protocols or follow their practices and protocols that are there to minimize the harm to domestic violence victims. And so when there are lawsuits, that puts people on notice. Even for individuals, if batterers knew that they could be financially accountable for the harm that they're causing and that they will have to pay, that could be an incentive for crime prevention. Certainly not in all cases, but it is one way. And lastly, lawsuits publicize the issue and promote change. And this can either be individually, where one victim sues one perpetrator, and then that person's name is in the public record. Any search of court records will see, oh, there is a domestic violence lawsuit against this person. And for some victims, that they feel like they are doing their part to help future victims. As a whole, generally, litigation about domestic violence publicizes the issue as a whole on a non-specific level. Disadvantages. When I speak to any potential client, I am so very upfront about the disadvantages from the beginning, because while there are many advantages, victims need to have a full and knowing idea of what this process entails, what the possible pitfalls are, and how very difficult it could possibly be. So it is just as important to consider all the disadvantages, both generally and case specific, for your victim. They're expensive. Any litigation is expensive. Now, generally these cases are done on contingency, which is often one of the roadblocks that victims come up against in trying to find an attorney to take their case, because attorneys have to be knowledgeable enough to know how to pursue this case and believe that it is financially worthwhile for them. But all of the same litigation costs are inherent in a domestic violence case as in any other case. Discovery, litigation, witnesses, and if it's not going to be economically feasible for the attorney, then it's likely not going to be pursued. Undoubtedly, victims are going to be subjected to the trauma of retelling their story, possibly either through depositions, through client meetings, and they're exposing themselves to scrutiny. By definition, mental health is going to be at issue. You're going to be seeking emotional damages, and when you put mental health at issue, then of course that opens that up to discovery. And so a victim needs to know that their past is all going to be fair game when it comes to discovery. And in my experience, one of the #1 tactics that defendants use is discredit the victim based on things that from their past. There are no perfect victims. There's no such thing as a perfect victim, and everyone has experiences in their life that brought them to where they were today. Just because a victim may have been victimized previously, whether through domestic violence, sexual assault, or some other trauma, does not mean it's not a viable case to pursue the victimization that happened here. However, you need to explore all of that and let the victim know that that past is going to be remotely relevant to this particular case, and they have to be prepared to be able to discuss that and endure it. #1 with all potential clients, whether it's civil litigation, family law, whatever way you are interacting with victims of domestic violence, getting them connected with good mental health services is so important, because the litigation is difficult for anyone, but reliving the trauma of experience that you have had is incredibly difficult. And it's so important that someone has good qualified mental health support along the way. Invasive discovery, like I discussed, obviously defendants are going to want to discredit and wear down the victim, and they do this through attempts at incredibly invasive discovery. We are going to talk more in a little bit about protections for discovery.
Jessica, you may want to talk about this when you get to protections, but a question came up that is relevant for now, and it's, can you use transcripts and depositions from the criminal trial if it ended with a conviction, or does a victim have to go through the entire discovery process again? Likewise, if a criminal trial ended in a conviction and the offender is incarcerated, can a civil suit be started against them right then, or does the offender need to be released? So sorry, two-part question that seems timely.
Okay, no, it is timely, and if I forget both components, remind me. But for the second part, yes, you can start it at any time. I think you're going to run up against, you're going to run up against a number of issues and protections that the defendant has while incarcerated. I think, and we'll talk about statutes of limitations later, you're going to want to be very careful. That's going to I think that's going to come, my answer is that's going to be a timing consideration. You never want to blow a statute of limitation, but there might be reasons to wait until after the defendant is no longer incarcerated, because that could affect a whole host of things, including the assets that they have available and your ability to get to those assets.
Do survivors have to wait until the criminal case is finished?
I am going to speak about that in just a few minutes.
Right. Okay, so the second part was, can you use transcripts and depositions from the criminal trial if it ended in a conviction, or does the victim have to go through the deposition, the discovery process all over again?
Well, you likely would not have had depositions in the criminal case. There are protections against witnesses, victim witnesses in criminal cases that would prevent them from having to give a deposition. So you likely wouldn't, and there are protections on the flip side, there are protections for criminal defendants that would likely result in them never giving a deposition. So you're likely not to have deposition transcripts from the criminal case. The trial testimony, yes, you can use that. You can use that for impeachment purposes. You're certainly using that for your evidentiary basis, but you cannot just port that testimony into your civil case in lieu of live testimony in the civil case. So you're still going to have that victim testify in the civil case unless they are unavailable. And so the cases, and being unavailable would be if the victim was murdered. And certainly murdering a part is a form of domestic violence, but the lawsuits that I'm focusing on today are done by a live victim of domestic violence who may have suffered strangulation, attempted murder, but who are alive and who are available to give testimony.
Thank you.
And yes, I have much more I'll talk more about the criminal intersection in just a few moments. So who does the victim sue? Number one, the abuser. That could be boyfriend, girlfriend, husband, wife. A familial relationship qualifies as domestic violence, but basically we're talking about one victim suing one abuser. But that's not the only option that victims may have. In some situations, victims may have other third-party defendants that they can also sue and may also collect upon. And for example, you have landlords. If landlords or property owners or have protections in place, things such as security guards, cameras, gates, things of that nature, and there is a failure in their safety protocol, and that failure is linked to someone being harmed as a result of domestic violence, you could have potential third-party liability here. And one of the interesting aspects to this, because the number one defense would be, well, I'm the landlord. How can I foresee, how could I know that this ex-husband was going to come and beat, my tenant? And I have no control over that. That's not a random, security risk that I can prevent against. And then the answer to that is you use statistics. Domestic violence affects 1 out of every 3 women. So there is an argument to be made that domestic violence is foreseeable. So if property managers or property owners, landlords have systems in place and victims rely on those systems, they rely on living in a gated community, they rely on lights working, they rely on rotating security guards, and those protocols are not followed by the landlords or property managers themselves, and that's a failure in the part of that potential third-party defendant. And so there's a potential case there. Employers also are potential sources of third-party liability. In California, we have, there's a duty to victims of domestic violence to make reasonable accommodations if they come forward and they request them because they are victims of domestic violence. And this is available in many other jurisdictions as well. And so these reasonable accommodations could be, a transfer of location, a change in schedule, safety protocols, including, accompaniment to the parking lot, lock installation. All of these things are relatively inexpensive and qualify as a reasonable accommodation. If these reasonable accommodations are not made or not followed through, or the protocols are not followed through, you have potential employer liability. You also have schools. Title IX is most commonly thought of with regard to sexual assault, but it also applies to domestic violence. It pertains to dating violence in all K-12 schools, colleges, and universities that receive federal funding. So victims of domestic violence have rights under Title IX, and if those rights are not followed, if they are abridged in any way, then there is potential Title IX liability for the schools. And a last subset of potential third-party defendants are parents or guardians. If you have a minor perpetrator, then it is possible you could also sue the parents or guardians of that minor for domestic violence. Generally,
Oh, sorry. There was a question, does it become detrimental for landlords to accept domestic violence victims then onto their properties? And are there laws set up to protect DV victims from a landlord who would be worried about that?
Yes, I can only speak to California. I know that it would be illegal for them to evict on that sense or to discriminate. I can't speak to the laws in other jurisdictions. I mean, I am sure that uninformed landlords who want to take that position could find ways to discriminate. But I would check the protections in your jurisdiction because, like I said, I know that we have some here in California. And so I would hope that other jurisdictions have that as well. Back to parents and guardians, I was saying that for many first-party defendant cases, insurance is not available. Homeowners insurance policies are written to exclude intentional acts. It is and that has evolved through the years. So what once was available to claim through insurance for domestic violence is now virtually impossible, but it is a possibility with parents or guardians. While those insurance policies exclude intentional behavior, when you talk about a third-party defendant who is a parent and you have a minor, then you really want to write your complaint for negligence. We're talking about negligent supervision, and you are suing the third-party defendant for the negligent supervision of their abusive child, not the actual intentional act that their minor has committed against the victim. So it's one of those things you want to think about in the beginning and make sure you're drafting your complaint or drafting your demand or whatever, however you're starting your case, so that you are setting yourself up for the easiest form of settlement. So the same types of damages are available for domestic violence victims. Your actual damages, general damages, punitives. We have in California some statutory attorney's fees that are also available. And so that would, you want to value your case in the way that makes sense to cover all of these options. So talking about valuation, there are very few jury verdicts and settlements to compare or to draw from. Number one, very few of these cases actually go to a jury, so you don't have jury verdicts. And number two, if they settle, they're quite often confidential settlements. So if it isn't a case that you've done yourself, it's very difficult for you to value the case. You have a high degree of emotional abuse, which is impossible to quantify. Now, that's not unique to domestic violence. That's the same problem that you have with any personal injury case, but you may have less actual damages to draw from. Not all domestic violence results in huge medical costs. Some do, but many does not. So you are not having as much of a base number to work from. But what you can do is value therapy. You can use experts to quantify the impact on the relationships, on the victim's ability to work. So you have to be a little bit using your imagination and facts to value your case. What I generally do is I kind of start with an approach that works backwards. I talk to my client about what are their goals? What do they believe is going to make them whole? And in my experience, a victim can quantify every financial item that they have spent as a result, either directly or indirectly related to the abuse. So this includes all of their lawyers' fees for obtaining a civil restraining order or perhaps advocacy in the criminal case, debt incurred because of the defendant. I mean, financial abuse is incredibly common, and if their credit is impacted or they have debt as a result of this defendant, that is a financial harm to the victim. And so I start with quantifying all of those potential out-of-pocket costs that you couldn't otherwise list in a restitution request or even necessarily include in actual damages, but we get that number. And then we look at what the defendant has, because in civil litigation, if you can't collect, it's not going to be worth bringing the case. So you can't sue someone for $5 million if they only have $500,000 to their name and no property. So every case needs to, when you're talking about first-party defendants, when you don't have insurance to draw from, you don't have third-party defendants, you have to really work with what that defendant has. And frankly, what makes an individual defendant pay is going to depend on their wealth. And so we are valuing the case with this kind of working between what will make the client whole and what is it conceivably possible to get from the defendant. And that's how we value the case. And when you are thinking of all of those individual expenses and things that you may not be able to fit into actual damages, well, you just use that number and you make that your general damages number. And that just encompasses everything that is going to make that victim whole.
Do you know about how many attorneys will bring these civil cases, and how successful are they, or what are we looking at as far as success rates?
So I don't know very many attorneys who do these cases. So I don't have a large pool to draw from. I can speak personally that every single one of my cases so far has settled to the satisfaction of my client. I am very particular about the cases that I bring and the people that I work with and the cases that I choose. And so, we've been fortunate to be successful, but I couldn't give you a range. I couldn't give you a number, because if you consider going to because of that factor of what the defendant has. I mean, I had a client whose arm was broken in 4 places and had, probably has lifelong nerve damage to her arm, as well as all of the emotional abuse and psychological abuse that she endured. And we resolved that case. Was it enough? Was it the price of permanent disability? No, it was not by anyone's measure, but it was for what he had. It was the most that we could get from him. And so that's what made that case successful. And that was successful to her too. Because if we went to trial and got a $10 million judgment, that's great. I'd have that's as, valuable as this. It's impossible to give a more specific answer to that question.
Thank you.
Definitely using experts to value your damages is going to be useful, especially if you do have a case that's going to trial, or if you do have a case with savvy defense counsel who really wants those kind of nebulous numbers quantified, because you can find experts who are medical professionals and domestic violence experts who can put a number to those damages. And that can either be through in-person interviews with your client, Or you don't also necessarily need to put your client through that if they're not up for another interview with another professional or another person. They can review the depositions, they can review, notes of other interviews and conduct that evaluation. Coming up with a diagnosis is incredibly useful as well. When you talk about emotional abuse, it is a stronger position to also say, and she has post-traumatic stress disorder, or she now suffers from generalized anxiety disorder, or taking this medication. So any more specific you can get to put a label on emotional harm is useful for your valuation. So I want to talk about the intentional torts that are available. And in California, we actually have a very specific domestic violence tort. Most jurisdictions do not. So while here in California, when I have domestic violence, I use a domestic violence cause of action. If you are in a jurisdiction that does not have that, then you are going to draft your case under battery and assault. You don't need a specific cause of action labeled domestic violence or sexual battery in order to bring these cases. All of those behaviors, whether it's sexual assault or domestic violence or stalking even generally, though that might be a little bit harder depending on the facts of your case, you can fit into and plead under a battery or assault. So do not be deterred if you do not have a sexual battery or domestic violence or even gender violence we have here in California. Other intentional torts are fraud. I have used this one when as a cause of action for STD transmission. That's a difficult cause of action to maintain, but certainly a righteous one to pursue if you have the facts, and that can be pled under fraud if you don't have a more specific cause of action. False imprisonment is almost always present when there's domestic violence. Stalking, again, the elements are very specific, and so if you don't have a stalking tort, you may be able to put that under assault. Or be creative. Be creative with the causes of action that you have available to you in your jurisdiction to get the fact pattern and the dynamics of the case into your lawsuit. We also have an image exploitation cause of action here in California, and as well as intentional infliction of emotional distress. And as with any civil case, I'd say plead all that pertain. Even though they overlap, gender violence necessarily overlaps with domestic violence. You plead them all, and false imprisonment, even when the facts are similar. Make the strongest complaint possible. It's particularly useful when you're drafting your demand letter to opposing counsel, when you have 9 causes of action that you plan on pursuing, and at least a number of them come with statutory attorney's fees. Side note, here in California, we have attorney's fees for domestic violence, and you could recover an award of attorney's fees even if it exceeds the amount you recover for the underlying cause of action. So there's an incentive for attorneys to bring those cases. There's less financial risk. So statute of limitations, like with any other civil cause of action, don't blow it. Domestic violence is a continuing tort. So if you have a specific domestic violence cause of action, as long as the last act of abuse falls within the statute of limitations, you can wrap up all the prior acts into your complaint. If you don't have a domestic violence cause of action, you're going to have to be careful about what your battery or your assault statute of limitations is in your jurisdiction. Getting back to the timing considerations with the criminal prosecution and hopefully answering the question that was asked previously. You do not need to wait until the criminal case is over. But there are a lot of reasons why you should if you can. Number one, if you have filed a civil case for your victim while the criminal case is ongoing, that provides an instant motive for your client, an instant financial motive that he or she can be impeached on. So you're just avoiding that altogether if you, as the civil attorney, are in the background and not. If there's no civil case, you avoid any appearance of financial motive. Also, the police investigation can provide the basis for your civil case. You're getting good information that's going to be part of you working up your case. Obviously, never blow the statute of limitations. If the criminal case is ongoing and slow and not resolved, that's not going to be any safeguard for you in not filing your civil case on time. So if you have to file it, you have to file it. And then sometimes, in my experience, filing a civil case can jumpstart the criminal case. We all know that there is no criminal case in many domestic violence situations, or their charges were pending and then they were dropped. You working up your civil case and doing that discovery might then hand the district attorney a nice package from which to prosecute the defendant. So it could jumpstart a previously stalled criminal case as well. So the affirmative defenses that you are going to be up against: number one, consent. This is most often used in sexual assault. Sexual assault can be both its own crime and tort, or it can be a part of the domestic violence. Sexual assault is a part of almost all domestic violence relationships. So it just depends on the facts that you are working with in your case. Self-defense, that is used 99.9% of the time in domestic violence cases. Batterers almost always claim to be the true victim, or they were fighting back or whatever. Just keep in mind that in true self-defense, you can only use the amount of force that's reasonable and necessary. So, I had a case where my client was trying to grab car keys from the defendant, from the batterer, to prevent him from driving while drunk, but was wrestling to grab the car keys from him. And then he strangled her. But his defense was that he was in self-defense. No, strangulation is not reasonable or necessary in response to someone taking your car keys away. Defense of others, and then minimizing damages. Defendants are always going to minimize the harm caused, whether they admit to part of the behavior or not. They are going to discredit the victim. They are going to say she was already harmed, that she was, they were a victim previously, that they were already damaged because of the child abuse they suffered, the rape they suffered previously, another abusive relationship. So they were already damaged before they ever met this particular defendant. So the damages that we can recover in this particular case are going to be much less. So the risks. Most batterers are narcissists. Most do not just take out their checkbook and settle. So you have to be aware of the ways they are going to retaliate, and the ways they're going to fight back, and the ways they're going to discredit your client. And your client has to be ready and prepared, and you have to be ready and prepared to deal with these. Defamation. There are defenses to defamation. Number one, truth is a defense to defamation, but so many batterers claim defamation after a victim has either applied for a restraining order or blogged or filed a separate civil lawsuit. So that is and I'm going to talk about the ways to counter that shortly. Similarly, malicious prosecution, retaliation in other ways. If there's an ongoing family law case, threatening to take the children away, if the victim continues the litigation, making false reports to the police or child protective services, anything they can to wear down the victim, they will do. And sometimes this retaliation comes in the form of a cross complaint. You know, I sue you for domestic violence, then you sue me for defamation. However, if it's the batterer who files the first lawsuit, then you should consider representing the victim in a cross complaint of domestic violence against that defamation lawsuit. It's a more, it keeps all the facts of both cases together and shows the judge or the settlement officer or whoever you were before what the full dynamics of the relationship really were. So here in California, we have anti-SLAPP protections, and that's also available in 29 states, have something similar to strategic lawsuits against public participation. So if you do have a batterer that files a lawsuit for defamation, whether it's in a cross complaint to your domestic violence tort, or whether it is a new lawsuit as a result of your client filing for a domestic violence restraining order, your first response is to file an anti-SLAPP motion. It is a special defense motion to strike, and it has very abbreviated deadlines. It is meant to be streamlined and less expensive so that you can dismiss frivolous or abusive lawsuits quickly. So definitely check out in your jurisdiction what you have available to you that is the same or similar to this anti-SLAPP legislation. Other techniques to protect the victim. Civil suits, you can file under Jane or John Doe filing. Depending on your jurisdiction, this might be a right. You don't even have to ask permission to do so, or you may have to ask permission, but given the privacy concerns, particularly if there are children involved, there should not be a problem with filing your lawsuit as a Jane or John Doe. Confidentiality agreements when it comes to settlement, and I'm going to talk about them more in just a second. Filings under seal, if appropriate, less common, but it is a possibility. And then discovery protections. This is really one of the most egregious abuses of power that defense attorneys use. And so it's where we as victims attorneys need to be on our toes and being the most creative at all aspects of the case. So, I mean, they're going to seek all kinds of crazy discovery that is just an invasion of privacy. Right now, I am dealing with a motion to quash a subpoena for my client's gym records that include like video of her on the elliptical. And no, it is in no way relevant. You know, lists of all her instructors for the classes that she takes. No, it's not relevant. So you want to always be careful. While yes, many things are a part and relevant to the case, not everything is. Some is just an invasion of privacy. Depositions, there are a lot of protections that need to be pursued when it comes to depositions. If you have a restraining order in place, there is not an automatic exception for the defendant to attend the deposition in person. So you need to be looking at other ways that this can happen safely and lawfully. So maybe they attend via video or telephone. Keeping in mind that if this is a high lethality case, a deposition subpoena is an invitation to a victim to show up at a certain place and time at a location that is most likely very unsecure. So even if you have an agreement with defense attorney that the defendant is not going to be present, you are still potentially putting your victim in harm's way because he knows where she's going to be at a certain place and time. So that is not applicable in all cases, but certainly something to be aware of in high lethality cases. So in those cases, you want to be looking for a protective order that is going to make the deposition at a location that is just as secure as the courthouse or at the courthouse, if you can even make that happen, with private security or law enforcement present so that your client is safe during the deposition. You know, ideally, all of these protections are being worked out through a protective order with defense counsel ahead of time. But this is one area that you should definitely litigate if you need these protections. You do not want to be negotiating your client's safety. That's off the table. So confidentiality agreements, I know I'm close on time, so I might talk a little bit faster than I might have otherwise, but the slides will be available to you if you want them. I do have some, more details on them. There are different trains of thought on confidentiality agreements, and even in California, we now have a prohibition against confidentiality agreements in settlements where there is sexual assault. And this is post-filing. There are many jurisdictions that are adopting prohibitions against confidentiality agreements, but other than California, to my research, it seems that all of the rest only pertain to workplace violence or sexual harassment in the workplace or sexual assault in the workplace. So California, I believe, is the only one that actually also prevents them in sexual assault settlement agreements. So make sure you are acting within the laws of your jurisdiction. And whether you enter into a confidentiality agreement or not, or whether your client does or not, has pros or cons, and that is something to discuss with them. Obviously, the con is that it is quieting the abuse. It's not letting other people have the benefit of the knowledge that this person is a perpetrator. Or on the flip side, you could get a higher settlement if the defendant believes that the settlement is confidential. Or a defendant might be more willing to settle if they can get it done with confidentiality, as opposed to, oh, well, this is out there anyway, I might as well fight because it's just going to be out there. Just a practice tip in California, if you are considering this, these prohibitions against confidentiality agreements only come into play after a lawsuit has been filed. So it is something to discuss in the demand stage, in the pre-filing stage, if you want to have a confidentiality agreement or use that as a leverage point in your negotiations. Many domestic violence victims are also dealing with a family law case, whether that is a custody case, whether it's a divorce case, a restraining order case, and there can be a lot of benefits to incorporating your financial settlement into an existing case. So restraining orders may also have laws that allow for certain financial recovery. Similar to criminal restitution, it's going to be very limited in that you are only going to be able to recover the actual damages, maybe medical bills, change of locks, attorney's fees. It's not going to cover the general damages. In the dissolution case or divorce case, you may address the civil damages in that settlement. However, knowledge of a potential tort case could also hold up your divorce proceedings. A defendant who wants to be divorced and wants to resolve all claims is likely not going to, add an additional X amount of money to be done, or, maybe they will, but it can also potentially stall your divorce proceedings because the defendant wants your marital settlement agreement or your judgment or whatever you call it in your jurisdiction to waive all claims. And if your marital settlement agreement waives all claims, you cannot then go file a civil lawsuit against that defendant. And so many times the case will get stalled between that provision of waiving all claims and the victim's desire to pursue restitution at a later date. So caution, and this is one of the areas where the siloed approach, it really comes into play. If your victim has a different attorney in their family case and you're pursuing the civil contingency case, be careful that family law case doesn't settle away your case, because you will have worked up the case and invested the time, and they end up settling it within the divorce proceedings. So it is very important to be a part of both cases, either as co-counsel or represent in both, so that it's protecting your investment as an attorney. It also allows the victim to make decisions with a global view. They're seeing all the opportunities and all of the options available to them and can make an informed decision for settlement.
So, We are right at time, and I'm watching people fall off. For those of you who would like to stay on, please do. And I promise we've got about 10 questions that
Okay.
I'd like to have answered. And as I promised, we'll circulate those questions as well. So if you'd like to stay on, you're welcome to. For those of you who have to drop off, I just wanted to remind you that we have another upcoming webinar on July 7th, and that will be on human trafficking. And we will send emails on that. Jessica, do you want to get to the questions, or do you want to finish? Up to you.
I'm gonna just, I'll wrap up with one finish, and then I'm happy to take questions. I would feel remiss if I didn't say this last point. Okay. So like the slide says, a siloed approach does not serve victims. It really is a benefit to be a domestic violence attorney and assisting your client, that victim, through all aspects of the case. Not only is it serving the victim, it's also self-serving as an attorney. If you're working with the victim through their criminal case, you're seeing all the evidence as it plays out, you're seeing how the case unfolds, identifying strengths and weaknesses, and you're also developing a rapport with your client and assisting them through the very traumatic criminal case. In the family law, when you're involved there, you're making sure that all of the possibilities are preserved. No one's waiving any future right to settlement or recovery on anything. If you represent in the restraining order, you are helping the survivor with safety and with the tools all around safety. And you're also getting to do discovery and depositions for potentially a restraining order trial before the defendant knows that there's ever any civil liability on the line. Because we all know that once money's on the line, that's a new kind of defensive. So not only are you setting up your civil case in the strongest way, you are assisting the victim through all of these different siloed and separate areas of practice that he or she needs to go through, and they have one consistent, partner on their journey. So I will leave it there and happy to answer questions.
Okay, we have 3 involving the criminal process, and I'll see if I can combine them all, or we'll just go through them. First, what kind of protections are there in criminal cases? This person had never heard of that. I'm not quite sure what they mean. Do you need to seek approval of the DA to use documents from a criminal procedure than in the civil process? And then if a victim is labeled as the primary aggressor in a criminal case, can they sue what they say is the primary aggressor in a civil suit?
Great, yes, great question. The protections, yes, victims have protections in the criminal case. That is going to be, there are some base level protections that all victims of crime have, but the more specifics are going to be jurisdiction specific. For example, in California, we have Marcy's Bill of Rights, which is incorporated into our California Constitution, and it enumerates all of the rights and protections that a victim in a criminal case has. And so, relevant to this discussion, it's going to protect a victim against discovery. They do not need to participate in any discovery for the criminal case, as well as many other protections. Sometimes, or oftentimes, it does require a victim's advocate or a victim's attorney to represent the victim in the criminal case to stand up for some of their victims. And that's going to vary depending on your district attorney's office and how victim-centered they are. Some are very good and very, on the forefront of victims' rights and keeping the victim's voice front and center. Others are not. So that's going to be location specific. The district attorney's file is acceptable. You can do a FOIA request, a Freedom of Information Act request. You're not going to get it while the criminal case is open, but you can get the full file once the case is closed. And you might not even have to do a FOIA request if you have a good now I'm losing my words, relationship with the district attorney's office. They may just hand it to you, but yes, you are able to get that. And the last, if the victim was the primary aggressor in the criminal case, a number of considerations here. It is possible that a victim could be convicted of the crime of domestic violence and also be the victim of domestic violence. I think if the case went to conviction and your client was convicted, you still could pursue the civil case, but you would want to think that through really clearly and make sure you have all of your experts and education lined up for whether, you know, the court or the jury or whoever you're in front of, because that's going to be a tough hurdle to overcome just because of the lack of understanding and the biases. I think if you had a case that was charged but not filed, it's a much easier call because you have those different standards of proof. There's been no finding that they committed domestic violence, so you could certainly pursue your case. You'll be up against the same evidence, you know, that was presented against them in the criminal case, but, you know, depending on the facts of your case, it's certainly doable.
And if somebody applies for state compensation, and I will give the caveat for you that this depends from state to state. But so for the states, you know, if someone applies for state compensation, the question is, does that affect their civil suit going forward? And I think nationally, what we see is more that it affects the civil, you know, the civil suit you have to pay back.
Mm-hmm.
It's the crime victims, but I'll let you talk about what the effect is in California specifically.
Yes, that's right. It doesn't stop you from filing the civil case at all. What I've done is I've been very careful to word my complaint or word the relief that I'm requesting to not also cover what has been paid from the victim's compensation board. So if they have received therapy, you know, 20 sessions of therapy at 80% for 3 years, then I am seeking beyond that. You know, I am seeking starting in year 4 through year 20. So I think, so you can word your complaint, you can word your relief in a way that you don't necessarily have to pay back the money if you are requesting separate money. If you come into a case that's already been filed and you don't have that opportunity to plead it differently, then yes, your client will have to pay back the part that is double recovery, but chances are it's definitely still worth their while.
Lots of questions about landlords and their responsibilities and what they're liable to. So are you limited in regards to the amount of requests for accountability from landlords? For example, if an abuser needed to move to a new place and break their lease, would the landlord be required to provide that accommodation? How does VAWA fit into all of this? And yes, I think that's it. Are landlords required to accommodate moves for domestic violence issues, and how does VAWA fit in?
I can answer part of that, and also this is going to be depending on the laws and protections that you have in your state. In California, we have an early lease termination law that requires landlords to break a lease for victims of domestic violence if they request it. So, and you give 30 days notice and the lease is broken and the victim is able to move. I know other states have similar laws. I do not know how many. I do not know the answer to the intersection of landlords and VAWA.
Okay. To the STD question, when you are pleading fraud, do you have to prove that the person knew that they were giving the survivor an STD, or simply that they did give the STD?
So I think this is going to depend on again, this is going to be jurisdiction specific. We have intentional fraud and fraud by intention and fraud by negligent misrepresentation. And they have different statutes of limitations. And so how you plead it is going to depend on what is available to you. Certainly the strongest case is that the victim knew they did not have an STD. I mean, these are very hard cases to plead. These are not easy. But in a best case scenario, you have to have proof, like to the minute that the victim did not have an STD. And then you have to have proof that the perpetrator had the STD and that the perpetrator, depending on which theory you're going under, either kind of negligently infected the victim or purposefully infected the victim, and that infection occurred from that person. So there's a lot of areas to poke holes in these cases, certainly. But if you have a strong one, it's worth pursuing. And chances are, I mean, if you have a relationship and you have a STD transmission case, you likely also have other elements of a domestic violence tort there as well. So you could plead them both if your STD liability is a little shakier.
Is there a specific cause of action in California for stealthing? Have you heard of this?
There is stalking. I don't.
Stealthing.
Stealthing? No, not familiar.
Okay. Can parents implead I'm thinking implead their civil responsibility insurance?
Implead their civil
Caller's still on, so if she wants to private chat me both of those questions, I will repeat them after she resends them. So we'll move on. Can you obtain information via a Freedom of Information Act for a juvenile if there is parental consent?
I don't know the answer to that off the top of my head.
Okay. Stealthing is when you do not consent to have a relationship without a condom, and the offender has a relationship without a condom. That is what stealthing is.
Thank you. Thank you. Well, that sounds like sexual battery to me. So there is not a specific cause of action of stealthing, but any sexual contact without consent. And it sounds like that would be, because that's not what the victim agreed to, that would fall under sexual battery.
Have you seen a rise in perpetrators' allegations against victims where the perpetrator is accusing the victim and essentially gaslighting the victim?
Yes, I mean, I don't know if there's been a rise. That has always been the case. In any area of my practice, this victimization of batterers is so very common. And it's a real risk factor for victims too. I mean, often a lot of the safety planning I do is, even kind of on a general note, if you know you have a batterer who is willing to call the police and claim that they're the victim, that's a real safety concern for the victim, because as we know, law enforcement doesn't always get it right. And then that puts the victim on the defense side of a criminal case or of a restraining order case. And getting to the courthouse first or calling the police first is a very common tactic. And it sets the dynamic where the victim is then starting off in a defense position instead of a strength position.
Last question, and then we'll email the rest. What about parent alienation? There have been a lot of cases where victims have lost custody to an abuser because the victim accuses the abuser of sexual assault of a minor. So what can be done to minimize the impact of losing custody, or the potential, I guess, of losing custody?
Yeah, I mean, that is a huge problem in family law, particularly. Victims who speak up, and that kind of goes to the point I made with where family law attorneys have a strategy of minimizing the abuse, because it is true that if you are in front of the wrong judge, the victim could look hysterical, overprotective, all of those things that then impact their custody and their parenting time. So, I mean, I think that is kind of one that, that's a reason for one of those strategies. And it's unfortunate that our system is set up that way. And I think that depending on what your jurisdiction is and what your, how active your appellate advocacy is. Here in California, we're so fortunate to have the Family Violence Appellate Project, which does a lot of work through appellate cases to educate the court about the dynamics of domestic violence and to quash those misconceptions about false allegations. I mean, the statistics show that allegations are likely not false. People don't go through the trouble of making false sexual assault allegations or false domestic violence accusations. but the myth is still there. And so the work is in the educating of the bar and the bench.
Well, thank you again so much for joining us, and thank you everyone for joining us again. I saw a lot of the requests coming through. We will be providing the slides, but then also a recording of this presentation will be available both on victimbar.org and on our YouTube channel, which you can find by searching National Crime Victim Bar Association on YouTube. Again, our next webinar will be July 7th, and that will be on human trafficking. Keep a lookout for emails on that, and we will try to get you all the answers that you need. Thank you again so much for calling in, and have a great rest of your day.
Thank you.